Some examples to give you a better idea of what law and economics is about. We turn to some examples based upon classics in the subject. First, we try to identify the implicit price that the legal rule attaches to behavior in each example. Second, we predict the consequences of variations in that implicit price. Finally, we evaluate the effects in terms of efficiency and, where possible, distribution. Example 1: a commission on reforming criminal law has identified certain white collar crimes, such as embezzling money from one's employer, that are typically committed after rational consideration of the potential gain and the risk of getting caught and punished. After taking extensive testimony, much of it from economists, the commission decides that a monetary fine is the appropriate punishment for these offenses, not imprisonment. The commission wants to know, how high should the fine be? The economists who testified before the commission have a framework for answering this question. The commission focused on rational crimes that seldom occur unless the expected gain to the criminal exceeds the expected cost. The expected cost depends upon two factors: the probability of being caught and convicted, and the severity of the punishment. For our purposes, define the expected cost of crime to the criminal as the product of the probability of a fine times its magnitude. Suppose that the probability of punishment decreases by 5% and the magnitude of the fine increases by 5%. In that case, the expected cost of crime to the criminal roughly remains the same. Because of this, the criminal will presumably respond by committing the same amount of crime. In Chapter 12, we shall explain the exact conditions for this conclusion to be true. This is a prediction about how illegal behavior responds to its implicit price. Now we evaluate this effect with respect to economic efficiency. When a decrease in the probability of a fine offsets an increase in its magnitude, the expected cost of crime remains roughly the same for criminals. But the costs of crime to the criminal justice system may change. The cost to the criminal justice system of increasing a fine's probability exclude expenditures on apprehending and prosecuting criminals. For example, on the number of quality auditors, tax and bank examiners, police, prosecuting attorneys, and the like. While the cost of increasing the probability of catching and convicting white collar criminals is relatively high, administering fines is relatively cheap. These facts imply a prescription for holding white collar crime down to any specified level at least cost to the state. Invest little in apprehending and prosecuting offenders, and fine severely those who are apprehended. Thus, the Commission might recommend very high monetary fines in its schedule of punishments for white collar offenses. Professor Gary Becker derived this result in a famous paper cited by the Nobel Committee in its award to him. Chapters 12 and 13 discuss these findings in detail. Example 2: an oil company contracts to deliver oil from the Middle East to a European manufacturer. Before the oil is delivered, war breaks out and the oil company cannot perform as promised. The lack of oil causes the European manufacturer to lose money. The manufacturer brings an action, that is, files a lawsuit against the oil company for breach of contract. The manufacturer asks the court to award damages equal to the money that it lost. The contract is silent about the risk of war, so that the court cannot simply read the contract and resolve the dispute on the contract's own terms. The oil company contends that it should be excused from performance because it could not do nothing, because it could do nothing about the war, and neither of the contracting parties foresaw it. In resolving the suit, the court must decide whether to excuse the oil company from performance on the ground that the war made the performance impossible, or to find the oil company in breach of contract and to require the oil company to compensate the manufacturers for lost profits. Superscript 9, which reads, for a full discussion of the cases on which this example is based, see Richard A. Posner and Andrew Rosenfield, Possibility and Related Doctrines in Contract Law, 6 J. Legal Stud 88, 1977. War is a risk of doing business in the Middle East that one of the parties to the contract must bear, and the court must decide which one it is. What are the consequences of different court rulings? The court's decision simultaneously accomplishes two things. First, it resolves the dispute between the litigants, dispute resolution. Second, it guides future parties who are in similar circumstances about how courts might resolve their dispute. Rule creation. Law and economics is helpful in resolving disputes, but it particularly shines in creating rules. Indeed, a central question in this book is, how will the rule articulated by the lawmaker to resolve a particular dispute affect the behavior of similarly situated parties in the future? And is the predicted behavior desirable? The oil company and the manufacturer can take precautions against war in the Middle East, although neither one of them can prevent it. The oil company can sign backup contracts for delivery of Venezuelan oil, and the manufacturer can store oil for emergency use. Efficiency requires the party to take precaution who can do so at least cost. Is the oil company or the manufacturer better situated to take precautions against war? Since the oil company works in the Middle East, it is probably better suited than a European manufacturer to assess the risk of war in that region and to take precautions against it. For the sake of efficiency, the court might hold the oil company liable and cite the principle that courts will allocate risks uncovered in a contract to the party who can bear them at least cost. This is the principle of the least cost risk bearer, superscript 10, which reads: the principle assumes that the entire loss from non performance must be allocated by the court to one of the parties. Alternatively, the court might divide the loss between the parties. Which is returning to the text, which is consistent with some of the decisions and cases that arose from the Middle East War of 1967. Chapters 8 and 9 consider this principle's foundation. Repeating previous sentence. This is the principle of the least cost risk bearer, which is consistent with some decisions and cases that arose from the Middle Eastern War of 1967. Chapters 8 and 9 consider this principle's foundation. Example 3. Eddie's Electric Company emits smoke that dirties the wash hanging at Lucille's laundry. Eddie's can completely abate the pollution by installing scrubbers on its stacks, and Lucille can completely exclude smoke by installing filters on its ventilation system. Installing filters is cheaper than installing scrubbers. No one else is affected by this pollution because Eddie's and Lucille's are near to each other and far away from anyone else. And far from anyone else. Lucille's indi- initiates court proceedings to have Eddie's declared to be a nuisance. If the action succeeds, the court will order Eddie's to abate its pollution. Otherwise, the court will not intervene in the dispute. What is the appropriate resolution of this dispute? Efficiency requires Lucille's to install filters, which is cheaper than Eddie's installing scrubbers. How can the court produce this result? The answer depends on whether or not Eddie's and Lucille can cooperate. First, assume that Eddie's and Lucille's cannot bargain together or cooperate. If Lucille's wins the action and the court orders Eddie's to abate the pollution, Eddie's will have to install scrubbers, which is efficient. However, if Lucille loses the action, then Lucille's will have to install filters, which is inefficient. Consequently, it is efficient for Lucille to lose the action. Now consider How the analysis changes if Eddie's and Lucille's can bargain together and cooperate. Their joint profits, the sum of the profits of Eddie's and Lucille's, will be higher if they choose the cheaper means of eliminating the harm from pollution. When their joint profits are higher, they can divide the gain between them in order to make both of them better off. The cheaper means is also the efficient means. Efficiency is achieved in this example when Lucille's and Eddie's bargain together and cooperate, regardless of the rule of law. Ronald Coase derived this result in a famous paper cited by the Nobel Prize Committee when he received the award. Chapter 4 elaborates on this famous result.